Number 39, Contact Chiropractic against the New York City Transit Authority. Counsel?
May it please the court. Good afternoon. My name is Agnes Niger. I'm an attorney with Jones Jones for the appellant, New York City Transit Authority. The issue that is presented before this court today...
Counsel, may I interrupt a moment? Sure. Would you like some rebuttal time?
Oh, I'm sorry. Yes, please allow me 3 minutes.
Yes, of course.
Thank you. So the issue that we're asking the court to address today is whether the 3-year statutory limitation or the 6-year contractual limitation applies in no-fault actions against the New York City Transit Authority as a self-insured entity.
Why should it be different for self-insured entities?
Well, simply, there is no contract of insurance, so there's no relationship between the parties.
Aren't you required to have a $5 million excess policy of insurance?
The Transit Authority is well, they're exempted from filing a certificate of self-insurance by vehicle and traffic law as well as public authorities law. I'm sorry, I can't answer in terms of the $5 million excess, but even if that were to be the case, I don't know if that would necessarily imply no-fault law, which is a statutory requirement. So you can't, there's no point to put a statute into, nevertheless, it's not a contract, Your Honor.
I'm sorry, you are not required to have a certificate of insurance?
Correct. According to VTL, I believe it's 370.
But I thought there was another VTL provision that required you to do so.
Well, common carriers, so the Transit Authority has two functions, both as the common carrier as well as a subdivision of the state. So according to the public authorities law, as a subdivision of the state, they're exempted from the sections requiring self-insurance.
So you do not have one?
Correct.
So even if the statute required you to have this excess policy of insurance, if the statute was removed, would there be any legal provision requiring that you provide no-fault insurance of any sort?
No, which is exactly the point. It's a purely statutory obligation, and if the no-fault statute were repealed tomorrow, the Transit Authority would not have this obligation to provide no-fault benefits.
How do you interpret what we said in LRAC versus Exum?
Well, LRAC versus Exum addressed the issue of the exclusivity of Section 11 of the Workers' Compensation Law. So, to distinguish it first, it didn't address a statute of limitations issue. And in that case, the court, I believe the court, it viewed LRAC as both an employer, where it was required, where there was this exclusivity that all claims against the employer go to the Workers' Compensation Board, but then it was also the owner self-insured. And just, there's a lot of precedent that states that just because you choose to self-insure doesn't mean that you provide any less benefits. And so in this case, all the benefits are exactly the same, and that's mandated by statute. So there is no lesser benefit that an injured party is getting.
But let's assume here that if you have an insurance company, in Aetna, one of the insurance companies, and you're providing no-fault benefits, the owner of that vehicle gets in an accident, there's a dispute, they file against the company that's insuring them for the no-fault benefits, that would be 6-year statute of limitations. Let's assume that under the contract. Why should a self-insurer, what is the policy reason that a self-insurer should get 3? Because a rental company can provide a proof of financial ability to pay, right? So in essence, aren't you saying you can buy a 3-year statute of limitations?
Well, it's not that you can buy it. The legislature gives you the option to self-insure, and the whole, the purpose
But that
of
has
insurance.
nothing to do with a limitations period. It really only has to do with financial ability, or a municipality issue, which is really a financial ability. So why aren't you saying if you can prove you're financially able, you get a 3-year statute of limitations?
Well, I mean, it comes down to the fact that, one is a substantive right where you have to give this benefit versus a procedural right. And the statute of limitation is, the purpose of the statute of limitations is to prevent still a defendant
But in the case of a rental company, you're giving that 3-year statute of limitation based solely on their ability to pay, their financial ability.
Right, I mean, and...
What would be the policy reason for us to do that?
because of the fact that they could issue payment.
Right, but why should they get a shorter statute of limitations?
Well, I mean, the argument very well could be made and should be made that all no fault should be 3 years, because the purpose of no fault, the reason they, took it out of the general liability was to create this prompt resolution of claims that accident victims
Couldn't the
have.
argument,
I'm sorry,
go ahead.
but that's not necessarily before us as to, those who have contracts of insurance today,
Correct.
right? So if we were to rule the way you want, we would have this dichotomy going on, and I think that's what's troubling Judge Garcia, with 3 and 6 between two different classes. I mean, and then it's just the vagaries of chance as to who you get in the accident with.
I believe that, a statute of limitations is a purely, it's a procedural issue, and it has to be viewed separate from the substantive, rights that a person have. The rights are exactly the same, so there is no benefit of a shorter period. A person gets the exact same, medical treatment, the $50,000, maximum amount. All of that is, the self-insurer has the same time to issue a denial. All the substantive benefits are the same. It's the fact that there is no contract between the parties and
But again, you're missing, I think, the point that you're being asked about, which is you have the opportunity to shorten the time frame by self-insuring, which, putting aside what you may be arguing about the statute of limitations, seems to be at odds and undermine the statutes that create the no-fault insurance regime. And that's where I'm having difficulty really appreciating the strength of your argument.
I think the questions that the court is posing is this fairness idea. And what I'm trying to say is that it's not an issue of fairness.
Is it different from other provisions that we have where in order to sue a municipality, you have to file a notice of claim within a shorter period of time or anything like
No,
that?
all those other benefits are
At
the
least
same.
not for something like the
For no
transit
fault,
authority.
it's
Let me
the
ask you,
same.
when did they demand payment?
When did who demand payment?
When did Chiropractic demand payment?
Can I look at I don't know
No,
the
your
exact
time
date.
is
It's an
up.
old,
Maybe you
it's
can
been
answer it on
going
the
on
rebuttal.
it's been going on for a long
You
time.
can answer it on the rebuttal, maybe your adversary knows.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. May it please the court. My name is Tricia Smith. I'm here for respondent. Okay, just to respond. She said that they're not required to have a certificate of self-insurance. That's incorrect. If you look at New York City Transit Authority v. Tom, THOM, which this court affirmed, it just said that the New York City Transit Authority is exempt from VTL, Vehicle and Traffic Law, Articles 6 and 7. It's not exempt from 8. And if you look at 6 and 8, they have the same requirements for 316, or under Article 6, it's for private enterprises and rental companies, I believe, and 370 applies to common carriers. And it said that 373 applies to 371, subdivision 1 and 3 applies to New York City Transit Authority. So they are required to get a form of financial security, same as any vehicle owner.
Well, but the point is that there's not a contract between them and someone else in implementing their no-fault benefits as there is with a personal carrier. And it's a relatively, I think that's the primary distinction here. It's the contract. And the certificate of insurance doesn't affect that one way or the other.
Well, the difference is that there is a contract. Our argument is there is a contract.
You're saying there's a contract for no-fault benefits?
So the contract is to provide insurance.
Well, but there's not a contract. It's not. I think we're getting down a rabbit hole here because there's not really a contract that says the city of New York has a contract with Aetna to provide no-fault benefits.
Correct. No, it's
Just like if somebody got in an accident with me, my carrier would cover it.
Right.
And we'd go forward from there. That's not the situation here. There's no contract that does it, and there's no common law right to this either, is there? This is purely a creature of statute.
no fault. The
course.
requirements to provide no fault is a creature of statute.
Right.
But anyone that an insurer of a vehicle is statutorily mandated to provide no fault, but that doesn't take away the coexisting common law right. You can contract to provide something that's unknown at common law, same as benefits, uninsured
But
motor.
isn't that the point, is that that if you take away this statute, what contract is there between the transit authority and these injured people to provide no-fault benefits?
I would say the contractual agreement was entered into between the self-insured when it was just a registrant prior to it becoming a self-insured. It's an uninsured vehicle owner. In order to switch from uninsured vehicle owner to a self-insured entity, they have to enter into an agreement. And if you look on the DMV website, which I put in my last brief, they agree to provide coverage. It calls it an agreement. They agree to provide no-fault coverage.
You mean
So-
this
so
is
you're
like
not-
our case, it says you're insuring yourself.
Correct. So I would say.
You have a
I just wanna be
statutory
clear.
requirement, you have to meet that in a certain way. Some people meet that through policies that are based on a contract. I take it your argument is others, like New York City Transit Authority, meets that through this other avenue that's available to them, which is to identify themselves as a self-insured. But what they're doing is, again, promising that they're going to comply with the statute by promising to themselves to pay.
Well, they promise to the Commissioner of Motor Vehicles. They're the promisor. They promise that they will, in exchange for the consideration of not having to issue a policy for each
Right.
individual right.
But the key point is there's no contract there.
Well, I disagree.
Okay.
Under the insurance law general provisions, it defines a contract. If I may.
But if the, well, I'll let you finish answering Judge Fahey's question, sorry.
Okay. Under the general provisions of the insurance law, it defines an insurance contract. It's an agreement or other transaction whereby one party, the insurer, is obligated to confer benefit of pecuniary value upon another party, dependent on the happening of a fortuitous event, et cetera. They obligate themselves in that application. That's where the agreement lies.
But that promise then is made to the commissioner, as you say, and then, people like Contact Chiropractic really are becoming third-party beneficiaries of
Correct.
this contract.
Exactly.
all right? So it's not that they are in a contract, in privity of contract with all these unknown providers of medical services.
Correct. But as is the case with a pedestrian with a normal insurance carrier, they're not in privity of contract with the pedestrian. They
Okay.
never have a pre-existing relationship.
So, I just want to understand the argument. So you're not saying that this is an implied contract, you're saying this is an express contract when they sign up with the commissioner as self-insured?
Yeah, I guess the word implied was probably misused as, it's implied to every individual injured from the use and operation of these insured vehicles.
I sort of come back to the problem of if you take away the statute,
Right.
what is there? I don't recall if this was argued, but I noticed that insurance law 5103H says that any written policy of insurance that fails to contain appropriate no-fault provisions will be construed as if those provisions were embodied in the contract, right? It sounds to me like the contract is really irrelevant, and particularly where, obviously we have some law that has been treating insurers differently, and whether that's good or bad, we're not talking about here. But particularly where here you're drawing in a contract by virtue of the fact that you're saying that this entity has promised the commissioner that it will comply with the statute, that it really is coming right back down to the statute that is the basis for this liability. There is, in this particular situation, there is no basis for liability in anything other than the statute.
And I think that's where it needs to be distinguished between the obligation, compulsory auto insurance. Every vehicle owner has to get insurance. But vehicle owners don't have to insure their own vehicle. They don't have to pay out the pecuniary value of no-fault benefits if they get into an accident, unless you're the insurer of that vehicle. And the difference can be seen in the penalties. If you don't get insurance for your car, you'll, get your registration revoked, you have to pay fines, but you're not going to get a judgment against you that says you owe Article 51 no-fault benefits. I just lost my train of thought, sorry. Whereas if you're the insurer and you make that agreement, whether by a policy of insurance or through the program of self-insurance with the Commissioner of Motor Vehicles, that agreement is what triggers the obligation.
But if you have a policy of insurance with an insured, right, that's a contract. It doesn't involve the state of New York, right? So arguably, that's different. If you have this so-called contract with the commissioner, and the only basis that the commissioner has to require you to abide by that contract is a statute, and the statute is removed, then what's the basis of the liability?
I would say in the same way that if the statute was removed, that an insurer has, the right becomes vested
Well, the
with the regular
insurer
insurer.
can refuse to put that in the next year's insurance contract, but it still
Right.
has a contract.
But it's carried out throughout that term of that contract. I would say the same applies to the certificate of self-insurance. In that application, you're agreeing to provide that insurance. That continues until that expires, regardless if the statute was repealed.
Counsel, circle back to the policy implications, and doesn't a shorter 3-year statute of limitations better comport with the considerations behind the no-fault scheme?
Actually, I think it's the opposite. They do use the term prompt, compensation, but the whole point of no fault was it was supposed to benefit the injured person. They were losing their right to sue and tort for minor injuries, so they were given in exchange a right for prompt, immediate compensation. To use it against them and use the prompt language, it was supposed to benefit them, not cut their time in half.
They sued under tort, wouldn't they have a 3-year statute of limitations?
Yes, but if they sued under, but that's a personal injury that's set forth by the legislature, 3-year statute.
So when was the demand made?
I don't remember
When-
off,
You don't remember?
but may I ask the relevance of?
Well, I'm just curious to, well, all right, let's ask the other question that I'm really trying to get to, which is how long, or were there any point in time after the demand that New York City Transit Authority explained why it wasn't paying?
I mean, I believe it was medical necessity, if I'm correct. The usual course of events is you submit the bill within 30 days, they have 30 days to pay.
Was the
delay
bill
or-
submitted within 30 days?
Yeah, excuse me, yes, it was timely, it was denied, and then it was brought to court, as any no-fault action would be.
Thank you, counsel.
Thank you.
Counsel?
So first, I just wanted to address what I believe Your Honor was asking me about, or Your Honors were asking me about the fairness notion of why there should be 3 and, versus 6, and for the, like, an insurer versus a self-insurer. And I just wanted to point out that that does exist also in personal injury actions where municipalities and the transit authority have a shorter.
That's by statute, right? That was a deal made in the legislature, wasn't it?
Yes.
This would be, we're implying this from the terms of a statute that has no overt implications for statute of limitations purposes. It wasn't that they designed this statute to give self-insurers this ability, having in mind we're going to give municipalities a shorter statute of limitations. I mean, that was a deliberate decision by the legislature to shorten the statute of limitations based on certain policy considerations and trade-offs.
Okay, I understand. Point withdrawn.
Sorry.
I mean, it's, yeah.
Have you found anything in the legislative history that would suggest any reason why there should be, or why the legislature thought there might be? Put aside the wording of the statute.
I don't know if the legislative history talks about it in terms of statute of limitations for the transit authority. Obviously,
Or for any self-insurer.
I think the legislative history was that, had more to do with treating all people equally and providing the same type of coverage. And that's not the issue
Suggests 6
here.
and 6, no? Or 3 and 3, perhaps.
Or, I mean, again, going to the substantive benefits of the time within which to pay a claim, the time, you know,
But you're saying you don't see a difference between saying, well, it's all the same benefits, but you get it for 1 week and you get it for 1 hour? You don't see it, that would mean a different treatment of those two classes?
I think the no-fault law in and of itself has sections where, you know, they toll statute of limitations if an applicant doesn't commence their action within 30 days of denial. So the statute itself is trying to create this quick and prompt resolution of claims, which
Well,
is the
quick and
purpose.
prompt would have been if you had paid, but that's not before us, right?
Right, exactly.
You see the problem
Isn't
is,
your best argument that it should be 3 and 3?
I mean, I believe, you know, this Court of Appeals has held that no fault is a new and independent statute, created a new and independent statutory right and obligation. And so if you look at no fault in general, then yes, I posit that it should be 3.
But as I see, the real problem with that argument is that you're basically saying when government, through statute or even regulation, but we'll stay with the statute, imposes obligations, but allows different ways to satisfy those obligations, that we continue to only look at the statute, the regulation, rather than the way in which the individual responds, which is what we have done in this area. Is there a contract? If there's a contract, it gets a particular statute of limitations. It seems to me the question before us is when you have a particular option to respond to the requirement to be self-insured, does that fall on the line of the contract or something else? But otherwise, your particular view has quite dramatic implications for our regulatory state.
Well, I believe that if this court were, you know, doesn't have to consider the implications all across the board because there is the distinction between an insurer and a self-insurer.
one of the policy implications that jumps out against me is, I'm a passenger in a car. The car runs into a bus in New York City, and I've got a 3-year statute of limitations under your theory then, right?
It's a little, well, the vehicle that you occupy is the provider of the benefits.
You're right, so I'm a
if you're
passenger on the bus,
correct,
and a
then
car runs into it, then the 3-year statute of limitations applies.
The 3-year statute of limitations happens after your benefits, for some reason, have been withheld. But your benefits are, you're entitled to medical treatment, you get that medical treatment.
But the statute applies,
Correct,
because I'm a passenger on the bus.
correct. and
If I'm a
there's-
passenger in the car, it would be 6 years.
Correct, because there is no contract of insurance.
That's the policy problem. That seems entirely arbitrary.
I believe that the CPLR is a procedural tool, and it doesn't take into, you know, consideration.
No, I understand that, but you understand that's the core of the policy problem.
I mean, I do appreciate.
But
appreciate
your
that.
argument incentivizes, and this is the question raised before, being self-insured, the trying to buy the shorter statute of limitations. So it's not just merely the fortuitousness of it. It's the opportunity to incentivize, right, to self-insure, to avoid a 6-year statute of limitations. That also is bound up in this argument.
I understand. I mean, to remove that incentive, though, a 3-year statute could be found across the board,
Which
and,
the legislature could also do.
correct, they could have.
Thank you, counsel.
Thank you, Your Honors.